address a question that is very interesting, and I've actually had quite a bit in my practice, and that's who gets to have custody of the pet. It's another interesting question, and you might be surprised that I dealt with this question quite a bit. The answer to it, though, is quite simple. The answer is no one gets to keep custody of the pet. The pet is treated like property. It is akin to, for example, owning a vehicle. The vehicle is in your name, so then it automatically is calculated as part of your property. So you treat the pet as a property. That being said, treating the pet as property means that you have to have evidence that the pet is yours, that you are the owner of the pet. And most of the times that comes down to who purchased the pet. Do you have receipts? Do you have any proof, any bank accounts regarding the purchase of the pet? Now, the pet can also be considered a gift, and you might have the argument that your spouse gifted the pet to you, and that's why, even though the spouse was initially the owner of the pet, now you became the owner by way of gift. It's a very difficult argument to make, but that is a very good way of approaching the situation if you weren't the one to be the owner. However, having said all that, I would not suggest to bring this question to the court. There has been litigation on the issue of pets previously, and I'm sure there's going to be a lot more litigation going forward. But if you were to bring this issue by itself to court, I do not think that the judges would be very understanding of that, and they would not want court resources to be spent on that. They wouldn't want clients to spend money on going to court either and on litigating this issue. So what I would suggest is trying to find a way to include this issue of the pets in your separation agreement. And there you can make as many adjustments as you want. You can provide for access to the pets. You can still have some ability to control what happens if you still see the pet after the separation. Because if you don't do that, then you might actually risk that the pet be treated as property. So maybe the court might determine that the pet is joint property. And with any joint property, what happens? If you have a vehicle in both names and you can't decide what to do with the vehicle, then you have to sell it and split the proceeds. So I do not think that anyone wants to do that, including the court. So a separation agreement is very advised, I would suggest, in these situations, at least on this issue. And if you are going to bring this matter to court, it better be along with other claims and not just this matter by itself. Just to clarify, okay, no one can bring a claim for custody to a pet, okay? That has been established in case law. A pet is property, and I'm going to quote a judge who made a decision in a case where there was a claim for custody, and he indicated that pets should not be claimed as they are children. They should not be part of a custody claim. They are part of a property claim. So let me quote what the judge said, okay? He says, "Obviously, I acknowledge that pets are of great importance to human beings. Strong bonds develop between them and human beings that look after them. To some people, the relationship with their pets takes on a significance exceeding that of any other. They go to extraordinary lengths to preserve that relationship, even at a cost that some would say is disproportionate. Some may consider them children. However, they are not children." And then the judge went on to dismiss the claim for custody. Therefore, it is not possible to claim custody to a pet. It's not as you see in the movies where you get evidence as to how attached the pet is, what is in the best interest of the pet. It's not as shown in Hollywood and on TV. It is a very different situation, so please do not make the mistake to fight too much over this. But of course, it is all up to you, and you should obtain legal advice when it comes to this.